My name is Oagile Dingake. I'm a sitting judge of the National and Supreme Courts of Papua New Guinea. Formerly, I served as a judge of the High Court in Botswana. I also sit in an international criminal court, the Residual Special Court of Sierra Leone. I thought it's important to start with paraphrasing the decision of the African Commission on Human and People's Rights in the case of Civil Liberties Organization versus Nigeria, where the court remarked that a government that truly governs in the best interests of the people has nothing to fear from an independent judiciary. How is the outlook of judicial independence in Africa? One of the things that I've noticed is that on text, in terms of constitutional provisions, it doesn't look bad, in that you'll actually find in many constitutions in Africa an affirmation of an independent judiciary. It is the practice that is inconsistent with the pronouncement that is in constitutional provisions. There are a number of basic standards on an independent judiciary. The first, of course, is independence. 2, you need an impartial judiciary. 3, you need a competent judiciary. 4, you need an honest judiciary. 5, you need an effective judiciary. 6, you need judiciary whose integrity is beyond question. And of course, you need an accountable judiciary. How does Africa fare when you measure it against all these standards? In Africa, the greatest challenge is that politicians simply have these temptation to control the judiciary. And this temptation leads them to interfere in the way the judiciary takes decisions. And related to that, it's of course the selection methods. The manner in which judges are appointed has a serious bearing on the independence of the judiciary. We are witnessing a phenomenon in Africa. It comes in various shapes and form, where executives or politicians hunt those that they think share their outlook, that they think are sympathetic to their positions, their agendas, their viewpoints, and that if they appoint them, it follows that they will then either excuse their transgressions or toe the line, so to speak. The third that I must mention is the resources. Starving the judiciary of resources. We can't just talk about judicial independence and not talk about judicial accountability, because the judges must not be the law unto themselves, because the judges too are subject to the law and are subject to the Constitution. It would be wrong and inappropriate for judges to establish themselves as the overlords of the Constitution. So judicial independence goes side by side with judicial accountability. Now, how do judges account? Judges account traditionally by convention every day. They sit in the open. Publicity, they say, is the soul of justice. Not only do judges sit in public, they are required to deliver judgments and to give reasons for that judgment. When they breach ethical obligations or engage in crime and such other inappropriate conduct inconsistent with judicial office, most constitutions in the region stipulate the process that must be followed for a judge to be made to account. I recall one Chief Justice addressing the media and the public and asserting and being prepared, said he will defend the independent judiciary with whatever is needed to defend it. That is for a Chief Justice to stand out in public, address a press conference, and say that it brings some hope, because the judicial power that we wield is actually delegated power of the people. So when you go back to the people and appraise them of the state of the judiciary, that's a very admirable form of accountability. And if you say you will defend the independence of the judiciary, you are living up to the oath that you have taken. So at the end of the day, the rule of law, democracy, and the independence of the judiciary can only be safeguarded by an informed, active citizenry that are determined to ensure that that which they put in the compact called the Constitution, that binds them and binds government, sets up limited government, they are able to defend it.